Under oath, he said it. He decides to think, but maybe she's suicidal. So she's getting a suicidal oil change, and I need to perform a traffic stop on this car. He saw a male driver. He knew it wasn't Mrs. Aguilar. Continued unlawful detention through coercion and duress. I'm going to arrest you in front of your children. Don't think you want. There are 4 independent grounds for suppression. Any one of them is sufficient. There was no reasonable suspicion for the stop. The reasonable suspicion evaporated on contact. There was unlawful detention and extension of the stop through coercion and duress. There was no probable cause to arrest. Under Terry v. Ohio and Outlaw v. People, a stop requires specific articulable facts linking this person or vehicle to criminal activity, not a hunch, not a generalized suspicion. When we look at that, Officer Von Felt had very particularized facts. He had a person, a vehicle. They were specific. He then was given, kind of this other information of, she sometimes hangs out with this friend when we're not getting along. He asked what vehicle the friend drives, right? He asked that. That was not provided to him. There was never a mention, if the discussion with the mother-in-law was reviewed, there was never mention that she had ever borrowed the car in the past. He asked what type of car Miss Ojeda drives. So he had, in terms of the call he was responding to, he had very particularized facts and specific facts. United States v. Cortez requires suspicion particularized to the individual. Kind of as I alluded to, Officer Von Felt's theory seemed to be that Miss Aguilar might in some way be associated with this Jeep now. That's essentially speculation layered on speculation. No witness, no report, no observation placed her in that vehicle prior to him stopping the vehicle. Like we said again, with no traffic violations. He said it himself multiple times. Now, on top of that, he then kind of starts to say, well, it was a welfare check. Once again, no one. This is a unilateral welfare check. Didn't come from the school. There's no mention of it. Didn't come from dispatcher, his CAD notes. This is a unilateral welfare check. He decides to believe that maybe she's in this other vehicle, speculation, a hunch, because she said she's getting an oil change. So he decides to believe that fact. And that he uses as some sort of justification to pull it over. But then he's saying he thinks he might need to do a welfare check because she was just fired. So he's choosing to believe through their conversation where she says, I'm fine, I'm good. The call with the school was a bummer, but life goes on and I got to get an oil change. He chooses to believe that part. She needs to get an oil change. So maybe, speculation, she doesn't have her car. So maybe, speculation, the car that I asked about, maybe she's in it or driving it. And then he decides to think, but maybe she's suicidal. So she's getting a suicidal oil change and I need to perform a traffic stop on this car. And it doesn't check out, and it's just layering hunch upon hunch upon hunch. So then when we move on to the next grounds for suppression, the reasonable suspicion would have evaporated on contact. As soon as Mr. Ojeda steps out of the car, the purpose of that stop is accomplished. People v. Redinger, when the purpose of a stop is accomplished, the continued detention becomes unlawful. Once again, under oath, Officer Von Felt confirmed. He saw a male driver. He knew it wasn't Mrs. Aguilar. He continued the stop anyway. And then we move on to this continued unlawful detention through coercion and duress. He continues the stop. He approaches Mr. Ojeda. When Mr. Ojeda attempts to discontinue the stop and enter his home, there is a fabricated charge. Essentially, it's going to be harboring a fugitive. That's a felony offense. When I track her cell phone here, I'm going to arrest you in front of your children. Don't think you want that to happen. And then he calls out a vehicle tow, start an impound on a white Jeep Cherokee, calls it out as loud as he can. We don't need to infer his intent in that because once again, under oath, he said it. He said he had, it's clear as day in the DMV transcript. He said he had nothing to say that Mr. Ojeda was harboring a fugitive specifically, and that it was directed at him to get compliance from him. Those are his words. That is the definition of coercion and duress. No one, if we look at People v. Davis, no reasonable person facing potential felony charges and felony arrest in front of their kids, a tow of their vehicle, which was called out and started, no one would feel free to discontinue that contact, remain away from that officer. That is the definition of duress and coercion, and a violation, an absolute violation of the Constitution and Mr. Ojeda's rights. That whole idea, his own purpose to get compliance, in his own words, is the definition of coercion. And I would direct the court to Turbine v. People, also in my motion, in reviewing the totality of circumstances surrounding challenged police action. Courts may consider whether the consenting or complying person was overborne by coercive police tactics. A threat of felony arrest in front of your kids, an impound of your vehicle, that is the definition of coercive police tactics. And finally, then when we move on in terms of what he cites to as his probable cause to support the arrest, we know we have absolutely no driving behavior. There's no mention of an odor of alcohol in terms of when the cover officer appears. And he repeatedly says, I don't have a driving action. There's no driving violations. There's no visible gross motor skills. What we are going on, and I think there's massive credibility issues littered throughout, is this supposed odor of alcohol, because we don't have any slurred speech, and there's really nothing else there. And that's, I mean, the fourth ground. The idea, I would just say, if at any point in time there's an argument raised that this was ever a consensual encounter, you know, I think the officer's own testimony refutes that. He needed to get compliance from him. Nothing about that is consensual. He pulls in, blocks his vehicle, lights on, that's a stop. The vehicle can't leave. And then in his own words, because there's nothing consensual about it, in his own words, he makes these threats to get compliance from him. That is the definition of coercion, and that's an illegal continuation of an already illegal stop. And so, you know, Your Honor, I don't think it's complicated. I think it's a straightforward Fourth Amendment violation. You know, Officer Von Felt, he got his call. It was to locate Diana Aguilar, a specific woman driving a specific vehicle, a dark gray Honda Pilot. Spoke to her by phone, confirmed she was safe, confirmed she was getting an oil change. This is the information he has. Later, he pulls over a vehicle that is not hers and approaches a man who is clearly not her. Any basis for the stop, however thin, evaporated at that moment. He had specific information. He chose to disregard it. Your Honor, we would ask that the court suppress all evidence for the four independent reasons that we have offered. If that doesn't warrant suppression, it's difficult to imagine what would. This is exactly the type of case that the Supreme Court was talking about.
Thank you. Mr. McGraw?
The people would start by saying that, yes, this is a complicated case. It starts with a call out for a completely different person and ends up in the arrest of Mr. Ojeda for driving under the influence. The original call about Miss Aguilar is that she had left the school building intoxicated. Throughout his investigation into her well-being, he determined that Miss Aguilar, when she has problems with her moms, including a situation like this, she would go to her friend's house, which is Mr. Ojeda's wife. He eventually spoke with Miss Aguilar and set up a meeting in the same general area that Miss Aguilar was reported to be. After he sat there for an extended period of time and Miss Aguilar did not show up, he decided to search and canvass the area. At which point he found a vehicle matching the description of Miss Aguilar's friend, registered to Miss Aguilar's friend, and then drove to the address that Miss Aguilar's friend lived at. All right. We think each one of these is reasonable suspicion to believe that Miss Aguilar was either at that location or behind the wheel of the car. And defense counsel's somewhat pointed this out already, that there may be reasonable suspicion to effectuate the stop at that point, but it evaporates when Mr. Ojeda gets out of the car. We believe the fact that this was a well-being check means that it doesn't evaporate when Mr. Ojeda gets out of the car. He can still continue his investigation to see if Miss Aguilar is at the residence at that point, which is what Officer Von Felt did on the day in question. He continued his investigation. As far as to his tactics and whether or not they were coercive, the people would point to the defendant's own actions. You're supposed to look at the totality of the circumstances to determine if a defendant is in custody, whether a reasonable person would feel free to terminate the encounter and leave. Mr. Ojeda terminated the encounter and left. He also exercised his Fourth Amendment right to be free of search and seizure by denying the officer the right to search his house for Miss Aguilar. After a few minutes of being inside, he then comes back out and restarts the encounter himself. All right. It's at that point that he admits to drinking, and Officer Von Felt has already seen him driving. Officer Von Felt also testified and has in his report that prior to that, he had seen bloodshot, watery eyes, the odor of an unknown alcoholic beverage, and whether it's up for debate on the gate, trouble working on the gate, all of which are facts, reasonable and articulable facts that point to driving under the influence. Combine that with the fact that the defendant himself admitted to drinking on that second interaction where he chose to come out and speak to the officer. We believe that both reasonable suspicion and probable cause have been met in this situation, Your Honor.
All right. The court's going to find that it does stem from a completely different reason that has nothing to do with Mr. Ojeda. The officer received a call that there was an employee who was terminated for being intoxicated at work, that she left the area upset, and that they believed that she was probably driving under the influence. So he went to try to investigate that. There was not any indication from the school or from anyone else that she was suicidal or that this was a welfare check. It was truly a DUI investigation. The officer does an initial check at her, tries to go to the home, ends up talking to her mother-in-law. He asks the mother-in-law to get her on the phone. He talks to her. There's no indication from that conversation with her that she is in any way suicidal. There is no indication that there's any need for any sort of well-being check. It's pretty clear at that point that he's trying to find her to see if she's driving under the influence. So then he talks to the mother longer. He makes comments that he felt like she was slurring her speech on the phone. Clearly at this point, it is 100% a DUI investigation of her, trying to find out if she is driving. Certainly the officer has the ability to do that investigation, but I don't think that at this point there's any claim that this was a well-being check. The court will find that then he was checking around, found another indication of a Cherokee that she might be driving. He could tell that it was her vehicle by the plate. He saw that a car go by a couple of times, but he has no indication that she's driving the vehicle, and there's no indication that that vehicle in any way makes any sort of traffic violations. The court's going to find that there was no reasonable articulable suspicion to stop that vehicle. That vehicle went by him twice, I believe. He certainly didn't identify her in the driver's seat, and certainly the person that got out of the vehicle was a man. It was clearly not her. So the court's going to find that, bottom line, there was no reasonable articulable suspicion for that stop. At that point, everything from that point should be suppressed as fruits of a poisonous tree under Wong Sung. The court is going to find and go ahead and make further findings just in case an appellate court disagrees with that initial stop. An appellate court decided the fact that there was grounds to stop her vehicle because they believe she might be driving under the influence, even though there's no indication that she was actually driving that vehicle at that time. When they see that it's a man driving, they're done under Redinger. I think they have to let him go at that point. There's not any grounds at all for even further contact except to say, sorry to bother you, and move on. It's also very clear that the defendant is not in any way engaging in a consensual encounter with the officer. So he repeatedly says he wants nothing to do with the officer. He won't let the officer in the house, won't talk to the officer, tries to go away from the officer multiple times. The officer then persists and goes over the edge by claiming that he's going to charge the defendant for harboring a fugitive. There's no indication that anyone even believes that there was a warrant or any sort of fugitive action about her. There's no probable cause for her at that point because nobody has her other than the school thinking that she might have driven drunk when she left. Then adding in the fake request to tow his vehicle to entice him to come back out again, the court is going to find that all of this is absolutely not a consensual encounter. There is no reasonable articulable suspicion to have contact with the defendant. The court's going to find all of the information that the officer found about the defendant driving under the influence was obtained after all of that illegal conduct. So the court is going to suppress all of the statements from the defendant, all of the observations of the officer, and find that there absolutely was no probable cause cause for arrest based on the illegal search and seizure. So I will go ahead and also make a finding that the statements were not voluntary based on the course of tactics used by the officer. So I show that we are set for trial readiness, and then we're set for jury trial on May 27th, starting at 8 o'clock. I understand that the people may need to look and see if they want to file any sort of appeal, and if they have any grounds to go forward. I don't think there would be any evidence left, but we'll go ahead and continue it to trial readiness to see where things stand at that point.
Thank you, Your Honor.
Thank you all very much. I know this was like a law school problem.